Hey, this stuff is coming really fast. I just barely posted a video about DeSantis's motion to disqualify the judge in the federal case against Disney. And just today, Disney filed its response asking the judge to stay on. And so I've gone through that, and I just want to go through that with you so we can see why Disney is saying, "Hey, judge, we think you should be able to stay." So the gist of this here is I'm going to pull up here. I have this is Disney's response, their opposition to defendant's motion to disqualify Judge Mark Walker. And then I have here is, so it basically have them both up. And where they're going to disagree here is they actually agree on the legal standard, which is a statute 28 USC section 455A, which is that a judge must disqualify himself from any proceeding in which his impartiality might reasonably be questioned. And then they agree that disqualification occurs when an objective, disinterested lay observer, fully informed of the facts underlying the grounds on which recusal was sought, would entertain a significant doubt about the judge's impartiality. And I mentioned in the last episode that this is a standard that's going to be really squishy. There's a lot of subjectivity in what is a significant doubt, what would a objective, disinterested lay observer who's fully informed, like, what does that even mean? And so that's where the disagreement is going to come in this case. DeSantis's motion was based on two cases where Judge Walker had used Disney as an example of a situation that might result in punishment for free speech. So here's how Disney is going to try and explain that that wasn't a bias that would result in qualification. So they say a prior statement relating to the parties or issues in the case will be disqualifying only if it connotes a fixed opinion, a closed mind on the merits of the case. And they say when we're looking at this, a well-informed person is not hypersensitive, cynical, and suspicious person. It's just a person that knows all the facts. And Disney points out that the courts must remain vigilant to the need to prevent parties from too easily obtaining the disqualification of a judge, thereby potentially manipulating the system for strategic reasons, perhaps to obtain a judge more to their liking. And I've talked about how DeSantis has said publicly that he didn't like the judge. He wanted this judge is going to be biased. The binding precedent holds that there is as much obligation for a judge not to recuse when there is no occasion for him to do so, as there is for him to do so when there is. So kind of a tight line there. So if the judges are stepping aside when they shouldn't, it says if this occurs, the price of maintaining the purity of the appearance of justice would be the power of litigants or third parties to exercise a veto over the assignment of judges. So basically what Disney is saying, hey, be careful. DeSantis is making it sound like anytime there's any question, you have to step aside, but you have to be careful because if it's not appropriate, you can't step aside. And so then what they're going to do is try and argue why DeSantis's representation of those cases that they referenced, the two cases, was blown out of proportion. The first one is Link versus Corcoran. These are the same cases that DeSantis cited. So plaintiffs in the Link case challenged the distribution of a survey to state universities about political views on campus. And I do think Disney does a better job of reminding the court what this case was about. But anyway, plaintiffs wanted to distribute a survey. To claim injury from the mere distribution of a survey, plaintiffs alleged that their speech was chilled because the state intended to cut university funding if the survey reported liberal political orientations. So I guess if the university did the survey and found that there were a lot of liberal leanings, there would be a cutting of funding. And so this was the case where the judge was saying, boy, this seems, there has to be a lot of assumptions for me to find that there's a chilling of freedom of speech here. The court said it requires you to assume the survey will show that liberal views are widespread. So there's one assumption. You've got to assume the legislature will react by reducing their school funding. That's another assumption. There are too many inferential steps. So he says, has the legislature actually said that's what they're going to do? And the attorney for the plaintiff kind of concedes that not particularly. And so the court goes on to say, well, I need something here. Give me a specific. And one of the examples he says, what's in the record, for example, is there anything in the record that says we are now going to take away Disney's special status because they're woke? Is there anything in the record that says, that you put in the record that says we are going to slash the funding? Like, give me something. What are you relying on to show that there was this actual threat of a discrete act? And then the judge says, I'm not suggesting that these examples would be determinative in this case, but is that even in the record to say, well, judge, here's what we've got in the record to show these fears are well-founded. So he's kind of saying, you have nothing in your record. Give me at least something. And so Disney is saying that's not showing a fixed opinion on the Disney case. It's just showing that he saw in the news that this was happening, and he's saying, do you have something like this? So yeah, you at least give me something to look at. So the judge and Disney goes on to explain that the judge ultimately denied the plaintiff's relief in that case. So the second case was the Falls versus DeSantis. And so counsel for the defense, who was arguing that plaintiff's claims about potential retaliation were too conjectural, similar to kind of the Kokorin one. And so the court asked whether it would be less conjectural if the plaintiff could identify other incidents where the state took actions against individuals because they expressed disfavored political viewpoints. So again, the court goes back to illustrate, hey, here are some ideas on things that might be examples of punitive action for expressing a viewpoint. He says, and then Disney is going to lose its status because they made a statement that ran afoul of state policy of the controlling party. At what point do you stack so many examples where punitive actions are taken if you don't do what you're told that suddenly it no longer becomes conjectural and you pass that threshold so you can establish standing? And I think he talks about a different case too, where as another example of actual action. So he's saying, in this particular case, again, you're not saying that there's any specific act being threatened against you, but can you even just show that there are other situations where the government has taken action in similar situations that I can look at and say, okay, then I see a legitimate threat that you're viewing here? Or are we just speculating that something might happen? So that's the context that the Disney case came up in those prior two cases that DeSantis objected to in his motion asking the judge to recuse himself. And essentially what Disney is saying here is that those two references don't show that the judge made up his mind about the case. It only shows that he was saying, is there literally anything that you could say that would show that there's a real fear that you would have? And candidly, I wasn't really that convinced at that point when I read through this, because it still seems like the judge had already kind of thought that it was punitive action that was being sought in the Disney situation, because he was using them as examples of punitive conduct by the government. But then there's another standard here, which when I look at that, I said, okay, well, now I'm wondering, this is a closer call than maybe I even thought before. But they talk here about that a court rejected disqualification in part because other actions of the district judge demonstrated his objectivity and neutrality. So again, a well-informed person, what they're saying is a well-informed person isn't just looking at the statements that you made, but is also looking at the judge, and the judge's past conduct, is well-informed of this particular judge and knows that this judge will be fair and has been in the past, and there's no reason to doubt that in this case. So the same is true here in spades with this Judge Walker, is what Disney is saying. In particular, this court, like any other district court, has heard many cases involving claims against the governor and other state officers and agencies. And as the court is well aware, it has often ruled in their favor. Indeed, too often to cite the decisions exhaustively, but they do cite some. Let's see, 1, 2, 3, 4, 5. These are all cases where DeSantis was dismissed by this particular judge, Judge Walker. So Disney says those rulings provide especially salient proof of the court's fairness and neutrality when it comes to Governor DeSantis. And then it cites here too, even the court noted in different cases regarding electoral districting disputes that the judge himself said, all told, I have heard 17 cases relating to voting in Florida. I ruled against Florida in 6 of those 17 cases, meaning in 11 cases he ruled in favor of Florida. Of those 6, Florida appealed 2. For 1, a motions panel denied the motion to stay this court's order, and a superseding change in the law then rendered the case moot, so that was resolved. On the other, the 11th Circuit reversed him, so decided the judge was wrong. As for the other 4, Florida did not appeal and change the law to conform with this court's order, so Florida was like, yeah, it's fine, we'll work with that. Of the remaining 11 cases in which this court ruled for the state, only 1 was appealed and eventually affirmed. So we're seeing a majority of the time here, in a majority of the disputed cases, this judge has actually ruled in favor of the state of Florida. So Disney says, especially given the court's lengthy record of consistent fairness and objectivity, no reasonable, fully informed observer could possibly conclude from its brief questions in the Link and Falls arguments about Disney that this court harbors an aversion, hostility, or disposition of a kind that a fair-minded person could not set aside when judging the dispute. This is another important part. One thing that that DeSantis brought up in his motion was that they objected to the judge being familiar with the news and saying, wow, he's looking at extrajudicial sources about Disney in the news and forming an opinion. And so that's wrong because you're bringing your opinion from outside sources into the court. And Disney does a good job of addressing that. They say the extrajudicial source doctrine, which means you can't look at outside sources, applies when a court expresses opinions about issues or parties in a pending case, like a case that's in front of it, that are based on extrajudicial sources. So if, for example, in this case, even in this decision, Judge Walker were to pull up and say, hey, I read on CNN, someone wrote an opinion about whether I should stay on the case or not, or something about Disney, and I thought that was really convincing. Well, that would, of course, be inappropriate. But our judicial system does not expect judges to live as moles, roving about the limited underground landscape of the official record, but never perceiving the illuminated world at the surface. Courts have said an open mind is required, an empty mind is not. So I say this on every motion for either side, but I think it's very well done. When I read DeSantis' motion, and I'm not digging into the background of these cases or anything, I'm just kind of reporting on it as if they come in. But I thought DeSantis' motion was a good point. Maybe the judge recuses himself, but again, I think what they're doing even more so than that is, even if they know that this judge has been fair to them, has ruled in their favor a number of times, and they honestly think he would be impartial and fair, just the optics of it, of a judge saying, I'm not going to recuse myself, I'm going to stay in the case, and then if he rules in favor of Disney, it gives DeSantis' side an opportunity to say, we told you, this guy was biased, and look what he did. Now we can hem and haw. So DeSantis' side has literally nothing to lose by asking the judge to recuse himself, and instead just gains kind of a PR advantage if things don't go his way in court. So now, having read Disney's response, and I guess DeSantis will respond to this as well, they did what any good lawyer will do. They'll say, I'm looking at the rule, I'm seeing if you got the rule right, and then I'm seeing if you applied the rule right based on the facts of the cases where the rule comes from and based on the facts that are in front of us now. And I think Disney did a great job of showing why the facts in this case don't support the recusal of the judge. And for me, the part that I thought was the most convincing was when you look at this particular judge and you show that he's been fair to DeSantis and the state of Florida and a bunch of other cases. I think, yeah, I guess when you look back at the comments, they don't seem so egregious that it would make me believe he wouldn't also be fair in this case. So with that, I want to know what you think so far. Do you think the judge should stay in the case? Do you think he's biased? Are you convinced by Disney? Or are you convinced by DeSantis' attorney so far? And again, when DeSantis files his reply, we'll take a look at it and see if the opinion changes. But one thing I love about litigation is when you hear both sides of the story, it's just really fascinating and interesting, and it can change your view on the case. And in this case too, I mean, we haven't heard DeSantis' side of the story and how he's going to present his theme and what happened and how they came to the decision of doing what they did with Disney. So I'm looking forward to seeing what he says. But so far, I think both sides have done a great job. So let me know what you think in the comments. And if you want to stay tuned for the response and for further details, please hit subscribe. If you learn anything from this, please hit like. I am going to eventually try and get to other cases besides Disney, but there's just so much going on and it's so fast. So I hope I'll see you next time.